sometimes like all you want to do is run. Hear me out, hear me out. It's all the things you never show. There are the things I want you to know. Secrets start in your heart to slow. But if you don't want to tell me now, I guess I'll never know. Losing almost all my energy. It's getting hard to talk to you, and I'm the only one who speaks. It's all the things you never show. There are the things I want to know. Secrets start in your heart to slow. But if you don't want to tell me now, I guess I'll never know.
Okay, you guys, welcome to the live. Again, we pushed it back about a half an hour's time because we know that the Defense Diaries is on as well. And there's a lot of people over there. When I was in there, it was like 1.1K watching. I know that it doesn't compare to our 20,000 that are just about to enter right now. Share your things off though. Charmaine, your tag or your microphone's off there, Missy.
I know I'm chewing.
Thank you again for Charmaine, and of course, Travis for joining me and Adam tonight. You guys, Travis, we know that there was a lot of issues going on, but you've left Colorado now. You had a really bad Wi-Fi night the other night, but it was what it was. You know, it was almost like it was actually like a comical night a little bit that night. You know, the chat was really saying a lot of things in chat, having fun, and you were popping in like popcorn, really. But
well, you know, I have a big sense of humor. Adam and I actually planned that all in advance earlier in the day to
totally
have that
scripted.
happen.
Sonny, he asked me for help in how to best connect to StreamYard, and so I gave him the best advice I could give him.
Yeah. No.
Oh man, that was just something else. I went back to listen to a little bit of it, and I'm just like, oh my God, those poor people trying to follow that. But we should have really good, strong Wi-Fi tonight. So,
and, you know, Travis, I have to say, because of that, we requested that there be a whole nother dump of, you know, documents in the Delphi case today, so that you could have another chance to come on and do your thing. So
well,
that Wi-Fi connection is the sole reason that all of us are here tonight now.
Yeah.
Well, I mean, you got it. Actually, I was poking around in Defense Diaries Facebook group, and Charmaine was in there and
Weird.
posted a thing about jaw-dropping, something like that, jaw-dropping documents. And I'm like, wait a minute, that's got to be from Friday. No, it's from Monday. And I'm like, you got to be kidding me.
So you knew Sonny was going to call you then?
Yeah. Well, I had messaged him and I said, don't worry, because remember we were talking about it, Charmaine, and it was like, you know, we got this, you know, this stuff isn't whatever. So I said to Travis that we weren't going to bug him tonight because we knew that he was heading back home after his month-long trip. And plus, you know, he said he had a bunch of work to do. And Adam was teasing him on Friday, basically saying, so see you on the live on Monday. And then Travis graciously again said, hey, I got time to do it. So Yeah, and then he went and he nicely, of course, highlighted these documents and sent them back, the ones that we're going to go over. So I want to say, because I did put out a video that you guys, so tomorrow Defense Diaries will be joining us here on the live tomorrow night. And so I put out this video that I really, well, I shouldn't say I hate it when I do that, but I'm so used to doing videos and stuff by myself. But it's Aspen and I. We want to thank you so much for, again, for Travis, for joining us, for doing the work that you've done, and just being a very kind-spirited soul. And same with Charmaine, always a supporter of the channel, and we love that, you guys. And so we just want to say just how much we truly are grateful for everything. I can't say that enough, to be honest with you.
And also to the loyal people that are in the stream watching every time.
Of course.
So thank you very much. And I noticed, I wanted to say welcome 0723 Trinity. She says they say my second show, first live. Welcome.
Yeah, welcome. I was going to say that name was new to me as well. So thank you very much for joining us. And before we get started, you guys, is there anything that anyone wants to say before we get into this document here? Anybody?
Yeah, I'd like, I saw a thing about y'all joining, or them joining you tomorrow, and actually saw that first. That's why I was over on the Facebook page. And then how did that come about? That's exciting news, because I think your channels complement each other to a great degree.
You know what, Charmaine, go ahead. You can explain that one.
Just after the show the other night, Sonny and I were talking, and I said that I'd reach out to Bob because he's always been very responsive and friendly to me. So I did, and he got back to me right away, and I told Sonny to reach out, that he was waiting to hear from her. So
and
yeah,
so
that's great. That's awesome.
And
Awesome.
And he answered back right away. So normally I don't have a problem asking myself, but because I knew that yourself and Charmaine especially, I've seen her in there, and I have with you, of course, Travis, in the Defense Diaries, so I was just like, actually, you know what, if you can just ask by chance, and then, let me know. And then, so then I messaged him on Twitter, and then he got back to me, and then he made a comment like that, actually. He's like, I have a sneaking suspicious that something like, we will get along. Can I say what? I'll say this tomorrow to them too, but I love it when Defense Diaries and like the Prosecutors podcast, what I love is when they really are grounded, and they're just basically putting it to us in simplified terms so that we can understand it. And I know you do the same, Travis. You want to explain it so people understand it. But for myself, someone that, like a lot of people have no clue about all the documents that are going around, you get the gist of them, but it's really nice when you can, when it's in a sense watered down for us so that we understand it in more layman's terms. So I appreciate the laid backness of when channels, instead of it being stuffy, that you can tell that both Prosecutors Podcast and Defense Diaries have a sense of humor to go along with it as well.
Right. And I have to say, I'm really excited to talk to them tomorrow night. I'm not a lawyer, so we all know that, but I haven't agreed with everything they've always said, but that's been their point of view, and of course, we're always respectful, but I'm super excited to hear their take on all these latest documents and just everything about the case, because I've never talked to them personally. So,
and I'd like to say that they've evolved.
I take a different
every time something comes out. So they evolve, and they do honestly tell it like it is. It might be a little lopsided, their point of view, but they are actually just going through the documents.
Absolutely. So I'm excited about it. I'm sorry, Travis, what were you going to say?
just that I take a different approach over there. I'm mostly answering unanswered questions in the most neutral way I can, because they don't have time to answer stuff throughout the day. They're focusing on getting stuff prepared and on multiple cases. And so sometimes questions go unanswered, and I just try and answer the basic stuff for them. I think I got a little animated when someone was trying to propose that they get Ken Kratz on their station so that channel so that they could discuss how all of that's behind him. He's changed his life. And I just, I didn't find any redeeming qualities, but that's about the only thing I've really asserted my opinion on. But, there's just basic questions throughout the day. And so that's kind of what I limit myself to, is just trying to answer unanswered questions. And because I don't want to be throwing this legal opinion out of left field, although I agree with 95%, but they obviously have, you guys mentioned when we were doing the popcorn episode that they had mentioned in a recent live that day or the day before that they expected something big to drop on Monday. And so obviously they know somebody either directly involved or closely connected with somebody directly involved. And a lot of what was filed today that we're going to get into in a minute answers kind of like a lot of these questions I know you all have had, some of your folks in chat have had, but that I've been thinking about in terms of why are they doing this? Why not this? Why didn't they file this? Why didn't they file what they did today? Because it was clear they knew they were going to be doing it. Why didn't they file that today with the first writ? But we'll touch on some of those things as we go through it.
Right. Well, with you mentioning that, Travis, first, I don't know if you'll get the reference, but, I'm sure they're grateful for your assistance, because to every bin chow, there needs to be a Camille. So, for anyone that didn't watch the Johnny Depp trial.
Okay, say it one more time.
For every bin chow, there needs to be a Camille backing them up. But that's a reference back to the Johnny Depp trial.
The Johnny Depp, yeah.
Which
I did not follow it all. There was just, but we'll talk about that another day. But that was the most interesting phenomenon. How right from the get-go, who had a major swell of support versus who didn't. I just thought that was a very interesting dynamic. And then when you looked at the swell of support, what the demographics were, especially by gender, that was fascinating to me also.
It was. One thing I'll be interested to talk to Defense Diaries about tomorrow night is, and I'm curious, I want to hear everything that they have to say, but I do want to know what information and context that they contributed to preparing the things that were filed today, because they were publicly thanked by the law firm that filed them.
Yeah, on Twitter.
Yep.
I think isn't it on Wednesday? I think I heard Bob say that Sleuthy Goosey was going to be on there, and Kara was going to be there on Wednesday.
So. But since we're talking to tomorrow, I will be interested just to hear if whatever they'll tell us, at least as far as what they contributed to what was.
Adam's given them a heads up. Just a note to the Defense Diaries when you see this. No. Okay. Okay, but you know what? Let's get into this document, you guys. Again, Travis. So we're going to do the verified petition of writ for Mandamus. And so I'm just going to you're just going to really guide me here. Scroll down. Wait, okay. So do you want me to go just to the highlighted part here?
Yeah, and I'll help you on the pages. Can everybody hear me okay? Because I switched over to Adobe. Okay.
Oh, there's Cowboy.
So,
Yeah.
okay, so it's verified petition for writ of Mandamus, which I will keep referring to as the RIPS. Got a new attorney here in this red box, Mark Lehman. At least I don't recall. He wasn't one of the 3 that filed the first writ. But I checked him out. Very well respected attorney in employment and criminal defense law. And then Kara's there again. And then her specialty is post-conviction criminal appellate work. And if we go down to page 2, I've got 4 things highlighted there in yellow. That it's excellent summary, and we're going to go through this one quick because it's all repeated in the next one. But I like the way they summarize things here. So they mentioned that they were appointed, Baldwin and Rossi, as public defenders. They worked on it for a year. And then they had some exceptional circumstances with this case that you don't get with normal cases. Gag order was misapplied. Again, this is their version, and we're just going to have to wait until the 16th, I think it is, for a counter brief if they choose to file one, and I'm sure they are, by the court, which is the judge. So a gag order was misapplied to pleadings filed in court. This was talked about in the first writ. The gag order didn't mention court filings. Protective order in a case involving thousands of discovery items. Adam and I discussed that on the popcorn episode when there was a protective order plus there's a gag order, and did one cover the other? Fortunately, this writ, if we get to that later on, helps answer some of those questions. What's the difference between the gag order and the protective order, and what did they prohibit? What is it done? What does it not prohibit? Then the issues about his confinement in the prison system versus the county jail, and then intense media attention exacerbated by a lack of access to the court records, which is the subject of the first writ. And then despite these challenges, Rick and his counsel made a strategic decision to be prepared to go to trial in January 2024. Y'all brought this up the other night. It may have been episode before last that we did, that somebody was mentioning, I believe Charmaine mentioned it, about they were talking about in defense diaries that not being critical, wrong word. They were discussing a lot. Why did the new attorneys agree to waive speedy trial? And this pleading answers a lot of those questions, what they were worried about. So they talk in here very specifically what their strategy was. Speedy trial, and to proceed to trial in early January 2024, and that they formulated a defense of third-party guilt, which I've been referring to as SODDI, S-O-D-D-I. Some other dude did it. Every attorney who practices in criminal defense or prosecution knows what SODDI is. So let's see. Let's go down to the next page. Again, this was just a summary. They were removed as his counsel. New counsel sought a lengthy continuance of the trial and admitted they did not know when they'd be ready to proceed. So this is helping the court, specifically the chief judge, who's doing an initial review to see if it has merit to order responding briefs or just to dismiss it. She's trying to show the harm and the prejudice to the defendant if the writ's not heard. And so they're showing the bare bones here and what's necessary in order for the court to entertain the writ. This part was important. Despite the exceptional circumstances, Rick has never wavered on this. Quote, attorneys Baldwin and Rossi are his counsel of choice. At every opportunity, he has reaffirmed to the court that he wants them to remain as his counsel. Then scrolling down to paragraph number 3, are you there?
I just I thought you were on the pinky stuff, and then I realized you were down further. Okay.
It's okay. It's okay.
So where do you want me to be right now?
Paragraph 3. Paragraph 3.
Right here. Yeah.
Shortly after their appearance, Rick's lawyers issued a press release affirming Rick's innocence when the charging information and probable cause affidavit were released to the public. In response, the court entered a gag order. The court also entered a protective order prohibiting the parties from divulging or otherwise granting access to the discovery relevant to this cause. And I've got a little note there. Going now to paragraph 5. And if we could have somebody read what I've highlighted there, paragraph 5.
Okay.
I'll read it.
Oh, okay.
Charmaine, go ahead.
It's your show, man. You go ahead. I'm just here for support.
We'll just take turns. We'll just switch it. Okay.
I'll read this one, and then in the 11 months, attorneys Baldwin and Rosie represented Rick. They had 2 leaks of discovery material occur. The first instance was inadvertent. Attorney Baldwin mistakenly sent a discovery log to a third party. Attorney Baldwin discovered his mistake later that day and rectified the matter. The second incident occurred after a close friend of Attorney Baldwin's secretly photographed a few items of discovery and leaked them to others, all without Attorney Baldwin's knowledge.
I would like to interject here. It's strangely satisfying, Adam, to hear you read those words out loud. I know you don't believe it, but I'm just saying.
Oh my God. Yeah, Charmaine and I worked on this all day to figure out what we were going to have Adam read and what Charmaine was going to read.
I mean, there's nothing in that paragraph that I egregiously disagree with.
So yeah, again, it's from their perspective, and this is a summary. And then I'm glad y'all had that exchange, because these things in brackets, R1 is volume 1 of the record and the page. And Sunny and Charmaine have obtained those, and we can go through them later. I don't know if we'll get to it tonight, but we can go to page 242 of volume 1 of the record and see how he rectified it.
Right. Travis, do you know what my favorite part of legal documents are?
What?
Footnotes.
I know, the footnotes.
Yeah.
Oh, gotta love those footnotes.
Always the footnotes.
Yeah. So, and then of course there's a lot of references about the leak. Let's see. Again, they're repeating. They adopted a trial strategy of seeking a speedy trial. They also formulated a detailed defense suggesting third-party guilt, Saudi. And then they prepared, the lawyers are trying to show the diligence of the defense, and they mentioned some filings. So, Charmaine, can you read on paragraph 8? Starting with filing a number of substantive pretrial motions, including, and then read through all of that and over to the next page.
including the following: a motion to suppress evidence, which will require a lengthy hearing involving multiple witnesses and exhibits. Reference R1.20. Is that how you say that?
Yep.
Motion in, you said that word, limine?
Limine.
Oh, limited. Okay.
Limine. Good. Regarding the reliability of the firearm tool mark comparison evidence, which will also require evidentiary hearing with multiple experts, and a motion requesting a hearing under Franks v. Delaware, which was accompanied by a lengthy memorandum and hundreds of pages of exhibits delivered to the court for its review.
Perfect. Thank you. So motion in limine, for those that may not know, is a motion. Typically, they're heard right before jury selection. And you're just asking the court that the attorneys and their witnesses, you have to instruct your witnesses if it's granted, not mention certain subjects or something. So if someone had taken and passed a polygraph, the defendant took and passed a polygraph, the state would bring a motion in limine to exclude evidence of polygraph. If the defendant took and failed or had an inconclusive polygraph, the defendant would bring a motion in limine to exclude any evidence of polygraph. And then the court would, of course, grant that because it's not admissible in any state, and unless both sides agree, and then it's still up to the judge. And so the court would grant it, and so that couldn't be mentioned by the state or the defense in selecting a jury, in opening statements. You have to instruct your witnesses. The state would have to say, hey, look, the judge is ordered, can't bring in polygraphs, so don't let that slip. And then if it does, that could be a basis for a mistrial and being in hot water with the judge. So that's what a motion in limine is. Okay. Motion in limine can also be to get a preliminary ruling before the start of the trial that evidence is admissible. Because if the judge is going to exclude it, it would alter the strategy of the prosecution or the defense, whoever's going to offer that evidence. Right. Here they're they brought this motion in limine to point out what the shortcomings are, what's up in the air currently about tool mark evidence on shell casings. Anyway, so, and the ability of a forensics expert to, quote, match, unquote, a casing to a particular gun. And you all knew that was coming. And then there's the Delaware thing. Again, the Delaware thing. I'm sorry, Adam.
I liked that you said it. I liked that you referred to it as the Delaware thing. Delaware.
Yeah. So again, they're talking in paragraph 9 about a speedy trial, and that they plan to file the motion locking in the January trial date. This was interesting. This second sentence: during a telephone conference between the parties in the court, Rick's attorneys informed the court that they were going to trial in January of 2024. And then there's page 37 of volume 2. And then, they're trying to show this timeline. Then it was after that telephone conference, it learned that photographs were leaked. Some people have been commenting in your chat and in other platforms that they were made aware of a leak as early as August of this year. So That's interesting.
Adam, well, just quickly, Adam, do you want to give reference to that a little bit or no?
Well, when you say they were made aware of, you mean the defense or the ex-defense team, I'm assuming.
Yeah.
I know that, I mean, the defense team in itself, you know, or the ex-defense team in itself in these motions talks about the leak occurring in August. And I know that, you know, there were YouTubers that knew about
Odinism.
that knew about, you know, for example, they knew about the Odinism thing 2 weeks before that memorandum even came out.
Yeah.
So I mean, this leak was known to the public, and I'm not talking about the crime scene photos per se. I'm talking about the fact that there was information being leaked from the defense, or from people associated with the defense, I should say, several weeks before anything was actually filed in court. So if the prior defense team wasn't aware of it, that in itself shows negligence, in my opinion.
Agreed.
Yeah. So
No.
there's no order regarding the pleadings, so I don't know. And we can look at those later, but they could send drafts to the media if they wanted. I don't know. No, it's not something I would normally do, but I mean, on high profile cases, when we were going to argue a motion, I had 20 or 30 copies printed up for the media so they could follow what we were going to do.
Not to be argumentative, Travis, but let me ask you really quickly, because I don't want to take up too much time. But in that information being sent out to people that are the public, I mean, the information that was that was being sent out, that was all information that came from the discovery material. Isn't that in itself a violation of the protective order?
No, not the way she worded it, but we'll go through it. And
I'm saying if that was sent out to the public.
Yeah, we'll go through it, and information that's in discovery by force of logic or definition, whichever way you want to put it, that stuff ends up in motions. For example, if there's a polygraph examination in discovery and you bring a motion way ahead of trial to exclude polygraph evidence, now she may have thought that, or she may have wanted it that way, but the protective order, and we'll go through it, is highly specific on who it can be given to, who it can't be given to, only one copy, et cetera, et cetera, et cetera. Doesn't say anything about court motions. I was surprised it didn't say, it didn't have a specific provision about attaching discovery or photos or whatever as exhibits. It doesn't even mention that. So while I would agree that would be against the spirit of the gag order, that's where PFD, the princess in the first writ, is.
Oh, come on, Travis, say it properly.
I'll do one at one point.
Okay.
But PFD, is saying the protective order did not apply to court filings, and it doesn't. She's right.
That's Maggie, right?
That's Princess of fucking Darkness. Yeah, on court records, but
until there's a court filing, all that information that's being disseminated into the public is is leaked discovery material. If there's not an official file, if there's not an official court filing
No,
out there,
it's not. It's not. A pleading is not discovery.
Hold on. Yeah.
And describing the discovery, quoting the discovery is not the discovery. The discovery is the discovery. The statement of somebody is the discovery. The video of an interview, that's the discovery. An expert report, that's the discovery. Describing it, it's not the discovery. Now, I don't know where people got that idea, but I'm telling you, in over 35 years of practice with gag orders and protective orders in federal and state court, and it's used all the time in federal court. What happens is one side can designate stuff confidential. You just stamp it, or you put it on with Adobe like a Bates number. But and then if you do that, to attach it, you have to file those under seal. So any documents that you want to use as an exhibit, including a deposition, what have you, you have to submit those under seal. But you are not required to file the motion under seal that describes that exhibit. You can quote from it, and if it's been designated confidential, then you need to redact that out of your motion. But this stuff, it happens in the most gruesome of cases, but we'll hear her take on it.
right.
And but it's like the tort claims notice. He had a legal right to file that. And if he doesn't file it, he loses any potential claim against the prison system for unconstitutional treatment. Right. And, we're right back to square one. Why is she directing her court reporter? And I know she is. Court reporter didn't come up with this stuff on her own. Why is she directing the court reporter to not transcribe those recordings? Now she's in a pickle, but we'll come back to.
I was gonna say, yeah. Let's Travis, we'll go back on course to this document, like I said, and then we'll come back to all these different things besides the ones that you want to talk about here. I don't want to get you off track because I know that you kind of wanted to go over this one. So if you want to we can do whatever you want. I'm easy.
Okay, no, it's fine. You have to talk about these things as they come up, otherwise they're lost forever. But we'll come back to all of that.
Sure.
Oh, well, since you said that,
you just gave him.
I have one quick question. There was a lot of talk in this, I thought, about their intention to file a motion in early November for a speedy trial, and I even saw the proposed motion that they'd written up without a date or stamp or anything on it. But isn't it moot? They never filed it. So intentions in a court case mean nothing until they actually are filed, correct?
Yeah, but it's critical to put things in context. So what's the context that they're looking at? They're trying to show that they had a solid trial date in January, that there was some discussions, and it's in their affidavit. It's one of the last exhibits in volume 2, that there was a phone conference, and that by requesting the discovery deadline, did that suggest that they were going to seek a continuance of the trial? And they told her, no, we're planning on going to trial in January. But yeah, whatever legal trigger there may have been by actually filing that, it didn't take place. But they're showing multiple things, and then they were in the process of filing that in early November to trigger the 70 days, and to show that they're just not making that up, they produced what they had him sign. But clearly that would have been after they were removed from the case, I would think. And so, yeah, there's a lot of, I don't want to say gamesmanship, because it's not. There's a lot of maneuvering here that's been going on since the hearing on the 19th, clearly.
Of course, yeah.
To set up a proper record, because it's hard to get a writ. So, but yeah, that in isolation would be a problem if they had to show that that's their strategy. But they've got a number of things in here that where they're citing, showing that our intent was to go in January, and now the client has got to wait essentially a whole nother year to have his day in court, and they're hooking that back in. You'll see in a minute that there's no remedy to have the thing go to trial and then have him assert those things on appeal. He loses his speedy trial right forever. Now, I think I would have liked to have seen, and what I'm sure we'll see from the other side when they file their brief, is why, I think how to say this, but they got an affidavit from and a letter and all kinds of stuff from him. And technically, you don't have to get the permission of your client to seek a continuance. That's one of those strategic things that an attorney can decide on behalf of his client, doesn't have to get his consent. It's not one of the 4 things you have to have client's consent on. But why isn't there something from the defendant, Mr. Allen, saying, I advise my attorneys, I did not want a continuance, or something in that regard, that I wanted to continue with this speedy trial strategy, but I'm sure we're going to see things like that he's submitted letters and affidavits saying he wanted to keep his counsel, but nothing about this speedy trial issue.
Right.
And I'm sure that's probably going to be one of the things, based on Charmaine's telling us about the MATA live, that they talked a great deal about the waiving the speedy trial and whatnot. was in the Defense Diaries episode, a live episode on YouTube. I'm sure that's one of the things that they maybe passed along, that that was a key deprivation. And so, yeah, they're going to put in everything, even if it wasn't actually filed, to, you know, support their argument that that was what the intent was from day one. Now, but you know, it's a complex thing we've got going on here, because that would have been timely in November. They say they've talked about it. They say they were relying on that trial date. She granted the motion to set a discovery deadline.
Right.
But after the 19th, she started withdrawing or striking pleadings and motions, and then ordering them withdrawn. But let's go through the basic facts here.
Can I ask you one more question?
Sure.
So optimistically speaking, with the new, you know, hypothetically, if, you know, this latest round of things, you know, is null and void, Gull stays on, Rosie and Baldwin go away for good, and this new defense team is actually allowed to do their job. Considering the fact that, you know, we heard repeatedly that Rosie and Baldwin had not received all the discovery. They hadn't received all of the discovery. They set this deadline, which was for November 1st, for them to receive all the discovery. They're now then saying that, you know, almost 2 weeks prior to that deadline, they were prepared to ask for a speedy trial, meaning they were ready to go in January, even though they hadn't at that point, according to them, received all of the discovery. So optimistically speaking, with the new defense team, they're, you know, going to, I'm sure, receive all of the discovery much quicker now. Can they then compel the court to ask for a speedy trial?
Well, they could, but they're not, based on what they represented.
Well, they came in day one, you know, saying, we haven't seen anything, we don't know anything, we just got appointed to this as counsel. They hadn't seen any discovery at that point. And, you know, the judge came, they said, we were thinking November. The judge said, well, we have Veterans Day, we have Thanksgiving, there was one other day. And so Judge Gull said, you know, we could do October, December. They said October, which is why they then set the court dates tentatively from October 15th to the 31st. But I mean, from what I read in all of the reports I've read and the court hearing, was they don't really know how much time they need. They basically all they said was their understanding is there's a lot of discovery to go over. So I think, you know, once they get the discovery, they're going to have a much better grasp on how much time they need to prepare a defense for Mr. Allen. So, I mean, could those new attorneys then say, you know what, we're ready to go in the summer if you've got dates?
Well, I don't know precisely how their speedy trial thing works. So,
Well, they said within 70 days, but my thing is, at what point would Richard Allen have
Those rights?
have a say in that? Because he, according to this paperwork, he's wanting a speedy trial within 70 days, which would take them to the January date.
right, that's
Right.
now.
Well, that has to
So
be filed.
what I'm asking is this: under their Speedy Trial Act, that says if you file this thing, your case has to be heard within 70 days.
Right.
And
How
then
long do
I
you have
don't
to
know what happens if it's not. I don't know if you have to show prejudice, or, you know, if the state shows good cause, then, they can extend that. I don't know the intricacies of it, and every state is different on that. But if I don't know if you have to file that at a certain time, more than 70, but less than 90 days in order to trigger it. I don't know. And so they were really big on, and we have the transcript of that, fortunately, because everyone who was reporting on it, and there was great accounts of, people in there seeing it. But everyone's got things they're picking out, and, who's saying what, and, what was Hennessy like to the judge, and so on and so forth. But there's parts in there where they're saying we have no objection to the continuance out to October, as long as it's charged to the defendant, as long as that time is charged to the defendant. And then someone made a comment, well, I see in their motion for continuance that they're in agreement, the new attorneys, that charge be time be charged to the defendant. So I think it's pretty much waived. So I think the answer to your question is no, they can't file a speedy trial motion for next summer, because they've represented in a motion to the court that they want until at least October, and they agree that time be charged to the defendant. And so they would say, look, you can't bring a speedy trial motion again until October, or until 70 days before that October date. And then that will lock it in. So no, I'm guessing with the prosecution being doubly sure who this time was being charged to, the 1-year continuance, they can't bring a speedy trial motion until August, and then they could lock in the October date.
Okay. So is there anything, and I'll move on after this. Is there anything in state law, and I know you don't practice in Indiana, but is there anything in state law in court that, so say they have this continuance, there's no speedy trial, is there any legal motion that this new defense team could actually file, though, that says, you know what, our client is still sitting in this facility, he's been in there now for over a year, we don't want him to then sit awaiting trial for another year? Could they compel the court to try the case earlier if there's time on the calendar?
No, they waived it. They waived it.
Okay.
So that's what their beef is with this writ, and why there's no remedy on appeal. He's gonna sit that extra year, and he's never gonna get it back because his new attorneys waived his speedy trial right and agreed to an October trial date. So that's if that were true, and the other side pointed that out, that, well, no, he can file a speedy trial motion anytime he wants. He could file one in February if he wants, or one in December, and then we're going to go in March 10th. So there's no harm. You'll see that in the response, but I kind of doubt it.
Hold on.
Oh, thank you for answering.
Thank you, Gail.
You heard super chat. $10. Thank you.
Gotta appreciate. All right.
Thank you, Gail.
Thank you very much,
So, and
Gail.
Travis, thank you so much. I'm going to let you go on now because I wanted to get that, clear in my head. So I'll probably ask you again another question or two later, but
Not if I get duct tape. No, just kidding. I just kidding. Okay.
Can't you mute him from your end?
yeah,
kidding.
but I can mute her too.
No,
Wait.
I'm just
it's
kidding.
okay. So paragraph 15.
So you want to go to 15?
That's what I'm down to.
Yeah, no problem. 14, 15.
They reasserted Rick's desire to proceed to trial in January. So again, they're pointing out to the court January. Court 16, the court ordered the clerk to remove Rick's filings from the record and it appointed 2 new attorneys. To preserve 17, Rick's chosen trial strategy, attorneys Baldwin and Rossi entered their appearances as his private counsel. 18, at a hearing on October 31, the court removed attorneys Baldwin and Rossi as counsel over Rick's objection. The court noted its grave concerns about their representation and said it could not allow them to represent Rick. 19, the court also noted that once new counsel had time to review the case, it would decide whether to adopt the pleadings filed, those are the ones that Charmaine read, as part of Rick's trial strategy and defense, or abandon them in favor of their own. Paragraph 20, I thought this was important. The day after attorneys Baldwin and Rossi were removed from Rick's case, undersigned counsel contacted the court reporter to make arrangements to prepare an expedited transcript of the relevant proceedings to file this original action. And then those transcripts of October 19 and October 31, the in-court made it, but not the in-chambers. So we're going to go real quickly through what the law requires for a writ. Paragraph 23, as developed below and in the accompanying brief, the respondent court has exceeded its jurisdiction in its removal of Rick's counsel of choice. Then it cites, noting writ of mandamus will issue where trial court has failed to perform a clear, absolute, and imperative duty imposed by law, which means, and we talked about this before, if it's discretionary for the court, it's an objection, irrelevant, and, that's not a mandatory thing. That's a discretionary thing in the view of the court, and you can't file an interlocutory appeal because the judge overruled your relevancy objection or denied the motion in limine regarding the tool mark evidence, or denied a Delaware v. Franks hearing, or denied the other suppression hearing that was mentioned. So they're saying what they're presenting, the court must do, fail to perform a clear, absolute, and imperative duty imposed by law. Paragraph 25, Rule 2A of the Rules of Procedure for Original Actions. That's what a writ, a mandamus is. An original action in the Indiana Supreme Court contains required condition precedent that the subject matter of the original action must be raised and ruled on by the trial court. In the first writ, they've cited the same thing, but they said, we can't give you anything that we satisfied the condition precedent because something the judge did, removed pleadings or something, or wouldn't rule. I can't remember specifically, but they quoted something else. We're asking the court to find that it's a legal impossibility to comply and excuse us from the legal precedent. Here they say, as explained more fully below in the brief, which we're going to get to in a minute, this was raised below in at least one motion, and the end of paragraph 25, the trial court ruled on the motion. grounds for writ of mandamus. Here's the law, paragraph 26. Original actions provide extraordinary remedies and will be issued only where the trial court has an absolute duty to act or refrain from acting. Mandamus is where you get them to act, where they have a duty to act, and then in the alternative, writ of prohibition, that's to get the court to refrain from acting when they clearly should not. Writs are appropriate for cases that strike at the heart of the public trust in the integrity of the judicial process. Citing a 2009 Indiana Supreme Court case, paragraph 27. On many occasions, this court has relied upon its original jurisdiction. Again, that's a writ of mandamus, to address claims such as this one, where attorneys have been or should have been disqualified. And they name 4 cases spanning 1982 to 2009. 78 to 2009. Those are cases that they've cited for the proposition that the Indiana Supreme Court ordered a judge to reinstate attorneys that they had kicked off cases. 28, and courts across the country regularly issue extraordinary writs in criminal cases to reinstate defense attorneys who have been removed from cases for conduct the trial court found upsetting or negligent. Again, they're pointing to the judge's ground to remove them was gross negligence, saying negligence isn't enough. They cite case from Tennessee, 2 from Texas, I think. Yeah. 1 from LA in 68, Stearns v. Clinton, which I'm familiar with, 1989. Lawyer removed from case for conducting witness interviews. That next page upset the judge. Another Texas case, Harmon, writ of mandamus appropriate where lawyer removed because judge had personal belief that an alternative public defender would be better. Florida and let's see, it looks like district court in Washington, D.C. 29, a criminal defendant in Indiana has a federal and state constitutional right not only to counsel, but to counsel of his choice. It's the 6th Amendment. And then the seminal case on that is Powell v. Alabama, going back to 1932, but was cited more recently in Harling, the 78 case they have there in that paragraph. Paragraph 30, the attorney-client relationship once established is inviolate. We're citing an Alaska case. When you're going outside your home state, it means you couldn't find a case to say exactly what it said, but it doesn't have near the authority if you're citing Indiana cases. Because this is in the Supreme Court of Indiana, they don't have to follow prior Supreme Court decisions. However, under the doctrine of stare decisis, Latin for precedent, because of the strong preference to try and be consistent with prior precedent, you want to cite cases from the Indiana Supreme Court. And the fact that they're going outside, and I make a note about this. This is true regardless of whether the attorney was retained or appointed as a public defender. Citing Smith, and I make a note here, weak authority. They really want an Indiana case that says that to kick off a attorney who's appointed, it's the same standard if they're hired, which is why they tried to do the workaround that they agreed that they would enter appearance for free pro bono to kind of get rid of that issue. 31, conviction attained. This is really important. Everyone really needs to pay attention to this part. and why it's important that we're going through this process now, that is going to cause a 3, maybe 4-week delay. A conviction attained when a court unreasonably interferes with an accused's right to counsel cannot stand, irrespective of whether the defendant has been prejudiced. And citing 10th Circuit case, U.S. v. Collins, and then United States versus Gonzalez-Lopez, which is a U.S. Supreme Court case. Judicial interference with a defendant's right to counsel is not subject to harmless error analysis, meaning you don't have to show that but for that, the outcome would have been different. All you have to show is it was done and it was done improperly, meaning we could, and we've said this several times in prior lives together, they could go through this whole process if they weren't willing to fight on these issues now in writs, go through the whole trial a year from now. He's found guilty and the issues brought up on appeal, and it's found that they were removed improperly. The case would get reversed and go back to trial, go back for another trial. Paragraph 32, there are only 2 situations where a trial court can sever the attorney-client relationship. Wheat, U.S. Supreme Court case. First, may be removed if he's not a member of the bar. They're both members of the bar. Second, may be, next, paragraph 33, Sonny. Second, an attorney may be removed as counsel when the representation prevents an actual conflict of interest. They weren't removed for a conflict of interest. In this situation, however, courts must be careful not to remove counsel where the government has created a conflict to prevent the defendant from having competent counsel. That's Wheat. Skipping down to 36, which is why I wish I had when I was on my phone during the popcorn deal, you had looked up stuff, Adam, that we'll talk about in the next phase here in a minute. You'd looked up some law and said you found something that to you suggested that the judge could remove attorneys. And I saw in the replay when I got disgusted watching my Wi-Fi go in and out, you had pulled up, but I hope we can get back to that. That's one of the unfortunate things is, and caused me to be really frustrated when watching it. You went to the trouble to try and research that, but we could never really get to what you found to see, that applied. Now, I'm sure if that's the case, it's going to be in the other side's brief, and we'll see that on the 16th. But anyway, I apologize for that.
No, don't apologize.
36. They're basically saying neither of those 2 situations applied. Now we're down to 39. The trial court held no hearing before the removal of counsel, depriving Rick and his attorneys of the opportunity to be heard on the matter. This is due process. The court also did not attempt to exhaust alternative remedies before permanently severing the attorney-client relationship, even though Baldwin and Rozzi suggested a remedy in the event the court was considering removal. And here's the sum and substance. Paragraph 41 in the red box. Adam, can you read that?
Sure. It says, the court should grant emergency relief and temporarily stay the proceedings below until a permanent writ is issued. Without a stay and quick resolution of this action, new counsel may withdraw the motions filed by attorneys Baldwin and Rozzi, or the court may summarily rule on them.
And then go ahead and read 42, and then I'll have Charmaine pick up on paragraph 43.
This court should grant emergency relief and immediately resonate attorneys Baldwin and Rosie as Rick's attorney. Each day, attorneys Rosie and Baldwin are off the case. Rick's trial strategy is placed in grave peril, and his remedy on appeal is non-existent. No appealable appearances have been rejected such that they cannot perfect an appeal in any event. Instead, the trial court continues to conduct proceedings at which Rick's rights will be affected, and the course of his ongoing trial strategy will be determined without the benefit of his chosen counsel. The exercise of this court's original jurisdiction is appropriate.
43.
Very zealous. Sorry.
43. This court should also order Rick's trial to commence within 70 days of issuance of a writ. Rick and his attorneys developed a speedy trial strategy and plan to confirm the January date by filing a speedy trial request in early November. So, Travis, I'm wondering what's your take on them personalizing Richard Allen to the Supreme Court by calling him Rick in this document? Seems a little
Yes.
Seems a little informal to me. Like, I don't know if it's appropriate.
That paragraph seems a little informal.
Mm-hmm. Well, the whole document, they refer to him as Rick, not Richard Allen, or...
Don't you think that was intentional? I mean, there's not one time I heard him as Richard.
Yeah, they started at the very top that they were going to call him Rick, and
Andrew.
Some states, like Texas, and our highest court for criminal cases is the Texas Court of Criminal Appeals. The Texas Supreme Court is the highest court for civil cases. So we have our highest court is a very specialized criminal court. The reason for that is because we have the death penalty here and we enforce it, or the state enforces it. So you need very qualified people, but anyway, I won't get into that. In Texas, we have rules specifically that we can't use first names for anybody. And really, we can't use names for any party. Can only use respondent, petitioner, plaintiff below, meaning the plaintiff in the trial court, defendant below, the defendant in the trial court. Apparently, they don't have those rules in Indiana because the lead attorney she's very experienced, as well as the other attorney we saw above. He argues cases in the Indiana Supreme Court all the time, and so I would assume that they would know. And if there's no specific rule against it, you of course want to, you want to do anything that's going to humanize your client. So it's a good observation. It's highly unusual where I come from, but we have specific rules that you can't do that in a brief filed in any of the appellate courts. But yeah, you want the court thinking Rick, human being, versus defendant, a number, a generic hypothetical law question, but it's clear why they're doing that. So they've asked for to be reinstated, and then 43, the red box, paragraph 43, this court should also order Rick's trial to commence within 70 days of the issuance of the writ, reinstate his speedy trial. And again, they mention that, Adam, that, that was their strategy. And they mention again that they'd planned to file the actual document in early November.
Right.
The new attorneys appointed by Rick's case have already asked and received a new trial date in 2024. They have also indicated they cannot be certain they will not need another continuance to prepare for trial. I don't know if I read it exactly like that, but anyway, 44. Can you read that, Adam, paragraph 44?
Sure. 44 says, finally, the court should remove the special judge assigned to this case and order appointment of a new special judge. In Indiana Judicial Conduct Rule 2.11 requires a judge to disqualify herself in any proceedings in which the judge's impartiality might reasonably be questioned, including circumstances where the judge has a bias or prejudice concerning a party or a party's lawyer. Indiana Judicial Conduct Rule 2.11A1. Here, the judge believed counsel was grossly negligent and expressed grave concerns about the representation.
And then over on the next page, those two lines.
Representation. Empathetically stated to Rick that she could not allow them to be his attorneys given her concerns.
Okay. I thought this was interesting. Again, about the media, paragraph 45, the international media attention this case has received suggests that for many people following the case, this may be their first time observing an Indiana court proceeding.
Right.
Rick has a carefully formulated trial strategy and detailed defense suggesting third-party guilt. The substantive pretrial motions he has filed to further his strategy and pursue his defense have not yet been ruled on. Going forward,
Right.
The public will question the judge's impartiality with respect to her rulings. To restore the public's trust in the integrity of the judicial process in this high-profile case, a new special judge should be appointed. I don't know if you remember, but way back up there, one of the legal grounds for a writ and getting it granted, and it was an Indiana case, is to restore faith in the judicial process. So here's a statement of precise relief sought. It's three things. We've already gone over them. Reinstate the attorneys, institute speedy trial, 70 days from the issuance of the writ, which if it got granted, let's just say December 1, that's going to put it at February 10th, plus or minus.
Well, can let me ask you just really quickly one more time, Travis, as far as, if you take all of the other situations out of this case, is it wise for any defense team, if they say they haven't received all of the discovery, to be requesting a speedy trial?
Yeah, because she just granted the discovery order, and
she granted the discovery deadline, but
right.
They at that point were saying they had not received all of the discovery. So how can you?
No. Your question is, should they insist on a speedy trial Absolutely, because
without all of the evidence.
Adam, discovery deadline. If the state doesn't produce it by November 1st, it's out.
Absolutely, no, I know that, but say
Right. So
let's
yeah, of course they're going to do it. The new
no, but I'm
attorneys,
saying let's say
it's
the
moot.
state let's say the state produces a damning piece of evidence. Could that not highly and influence the type of defense that the defense takes?
No, the state's not going to find something hugely exculpatory.
I'm saying,
and they've got a constitutional right to turn it
Yes, they do.
over, and the defense would use it. It's totally in the defense's favor, and so no, because she granted the discovery deadline,
that's not a
which
question.
I was surprised that they should have been pushing for a speedy trial.
I personally try not to make up my mind before I have all of the information when I do anything in life. So if I was holding,
you're trying to solve a mystery. These
I'm not trying to
two
solve a
men
mystery.
are trying to defend a man's life, and the state's required to produce this stuff. The state's required to produce this stuff timely, and if they don't, it's out. So of course you would want an early trial. You don't. You're going to wait for these. You're going to wait for with the history of these guys.
Well,
took
then why didn't they request
5 years? No, these guys are bozos. You're not going to wait for them to turn over discovery.
Can I say one thing here?
Yeah.
Because the chat and me and Charmaine, I mean, we love this whole little debate that's going on, but when people are talking each over, so just let Adam, let Travis finish, then answer back or whatever.
Yeah, the answer to that's real simple. You don't wait for the state, because the state always dribbles this stuff out, and they do it intentionally, and they do it right before trial to throw you off your game. I mean, all prosecutors do it. So I was surprised that she granted it months ahead of time. They had to get their stuff and have it ready to go by November 1, or they were toast. They've got to prove their case. He's innocent. So why are you going to give him more time to, dribble this stuff out? So they had a huge advantage over them. There's, you see it in cases like you waive speedy trial, and they waived it on behalf of OJ, and I think he sat in jail for close to 2 years. But there was so much scientific stuff that they needed to get done, the judge was having problems. The discovery deadline was fast approaching. And then she hadn't ruled on all of these motions. And if she granted the motion in limine, the motion, forget the Franks, but the other suppression motion, which I haven't even seen, let alone the first 30 pages of it or whatever it is. But they really had the state scrambling, but not anymore when they waived it, and it's at least a year out. And that's a major thrust of the brief, because that's the way it aligns strategically for them. What are our best arguments? And no notice, no hearing on the finding of the gross negligence. Okay, what else we got? How does this hurt Mr. Allen? We need to show that a normal appeal won't take care of it.
Right.
Well, that's been our strategy from the beginning. I mean, we had them reeling, and that's why they're bringing up stuff that the judge was asking if there was going to be a continuance, if all these different things. But no, in a case where they've been dribbling out discovery, and that was the basis of their motion from what I recall, and I don't think I actually read their motion. I just read the order, and just remember I was surprised that she granted it. That told me at the time that she was, I thought, very impartial before all of this other stuff came up, that, well, that's a major victory for the defense, because in reality, the judge is keeping everybody's feet to the fire, because that's the only way cases get resolved without a trial.
Right.
Is no, we're going, and then if there's a real legitimate reason, they'll continue the case. But they're telling everybody we're going. No, that's the date, because that's the only way dockets move, and they'll put deadlines. I'm not going to accept a last minute plea deal. If you guys are going to have a plea, it needs to get done at least 30 days before trial. Otherwise, your client's got to plead open. They do a bunch of different things to keep people's feet to the fire, because for most defendants, they believe if you wait till the day of trial that you're on the courthouse steps, figuratively, that's the best deal. And that's the only way some judges feel to get around that myth. But in any event, they got that granted, and that put them at a bit of a strategic advantage if they were, but that's only if they were in the process of doing any type of investigation. There was stuff in process, and a lot of this stuff, Adam, is just very, very difficult to say, because in Indiana, you get depositions in criminal cases.
Absolutely.
And we know they have taken numerous depositions. We know that Baldwin went and interviewed 10, 15, 20 people in prison. That's probably 250 hours worth of work right there, that might need to be repeated by new counsel. But that's separate from, and this massive discovery, 90% of it's going to be that first how many ever years. And then, and that, it was all dead ends. And that is time consuming discovery, because if your defense is a third party defense, you have to track down all of those dead ends as a defense lawyer to find out if they were really a dead end, right?
Right.
And that's what the odious thing's all about, that apparently there was another investigator. And anyway, pull up 2, Sonny, would you? And we'll go ahead.
Well, I just want I wasn't at all saying anything about the discovery deadline. I agree with you 100% on that. Like, that was giving an advantage to the defense, because that's not something that normally has to happen 90 days before trial. It's different in every state, but the point that, in Indiana, all it really says as far as that you have to turn over discovery within a reasonable amount of time before a trial, basically.
Right.
But in this case, Gull issued this deadline for November 1st. The point I was making was that if you are Richard Allen's defense team and you have been defending him for a year at this point, and then here we are, let's say 90 days before, before the proposed trial dates, and you're in one breath claiming you don't have all of the discovery, that the state has not been forthcoming, you don't have all of the information, and this is even still almost 2 weeks before the deadline that Gull has proposed, that Gull has set, that everything has to be turned over. So, like you said yourself, that the state can dribble out this information. So what then would keep the state from withholding the most damning evidence they have for the last minute? And so if the deadline is November 1st, all I'm saying is that Richard Allen's defense team can't at that point be certain that the state does not have something in their possession that's damning to Richard Allen's defense. Yet at the same time, they're claiming they want a speedy trial, that they're ready to go 70 days in. My only point was, I feel like that is kind of a hypocritical statement to in one point say, we don't have all the information we need to present this defense. And at the same time, they're saying, we're ready to go in a speedy trial.
So they're going to get, if you adopt their view and they get the rulings that they want, we haven't even got into what could the possible rulings be, which, for example, could be they're ordered to be reinstated, but Judge Gull stays. Or they're ordered to be reinstated, Judge Gull stays, another judge below needs to hear the disqualification motion. Denies it outright, says it's premature, he can raise this issue on appeal if necessary, meaning they're not going to decide any of it. But if they get all three things granted, they're going to get a new judge, and then they're going to ask the new judge, when they set the new trial date, as part of that, they would ask the new judge to impose another discovery deadline. And now they can hold on to stuff, but now they've got a record in the case, even though it's previous judge. So the state's probably not going to risk holding on to the most damning evidence until the week before trial, because they would have to show that they turned it over in a reasonable time or risk it being excluded. And but yeah, they've given up by saying we want to come back in and we want the speedy trial. But that's true. They have given up the November 1 discovery deadline, potentially, because it just depends on how the court orders. If they do rule in their favor, they do have an argument that I have to read the transcript. Did the judge? I guess everybody is assuming, rightly or wrongly, that by continuing the trial, that automatically nullified the discovery deadline, and it doesn't. Now, if the state sent a motion for clarification or to amend that order, I'm sure she would grant it. No question. But, that's still an assumption. So if the new attorneys come back in and they set a date 70 days out, the state's going to have to come back in and get that thing clarified, because it's not automatically void. Although, it's a big gray area. So, the defense would have to, if they wanted to rely on that, they'd need to get clarification on it too, either with Judge Gold if she remains, or the new judge if there's a new judge. And then it's all moot if the court doesn't reinstate them. So, but, here's what they're fighting, and so you have to prioritize these things. Our client wants us, he has the right to us. Our view is she denied due process in the way his court-appointed counsel of his choice were removed. She didn't really have a hearing. She didn't really provide notice. So goal number one is get the attorneys reinstated. Then, but what good is that if she already thinks they're grossly negligent and not providing a good defense? Well, she's biased, so we need to get her disqualified. Okay, then where are we at? They come back in and they got a October trial date, and the main strategy was to keep the state's feet to the fire, because they were, they're behind a bit, and I think we caught them off guard. Then what do we do? Well, it's, ask for reinstate the speedy trial, and then, we're risking that maybe that November 1 discovery deadline is gone, and who knows what number that is. But, there's no question it would need to be addressed. My only point is it would be way, way down the list compared to those top three. And you wouldn't let an issue like that become the tail that wags the dog.
Well, I like that analogy. Okay, so I'm ready to let you move on. I'm so sorry, Travis. I'm done this.
No. I mean, so all right. So now you got two up. Relators brief in support of petition for writ of Mandamus.
Yeah, I just want to say something that Fig said earlier, because this was correct, because McClellan said that he had already handed over all the discovery. Do you remember that? Yeah, McClellan had said that, and when Fig put it up there, I was like, yeah, I remember that. That he had handed over all the discovery. So that was just to point it out. Travis, give me 2 seconds, because as for the crime scene photos, the only person, like Ivy said, that I remember myself was Chris Todd going on to Court TV talking about some crime scene photos. Vinnie Politan would not put them up at all. And even Rick Snay was like, but those are a whole different ball of wax. So Trinity, unless you're speaking like of something else, that's the only one that I recall as well, because the second set is the ones by Mitch Westerman. So whatever else is in the muddle of all of that, no idea. But I do know that those are if you're talking about Chris Todd, then there's those pics. Those are separate, and they're from a whole different person than the pics that Mitch Westerman's went. That's about what I know about that stuff.
I mean, there was, and I might be missing out on what you're talking about. There was talk in one of the filings that we read today that talked about Court TV and Barbara McDonald.
Oh, okay. Is that the one where Barbara McDonald was talking about on the Court TV? That one, is that what you're referring
there was
to?
a reference, so I don't know if that's what someone was referring to or not. I heard Court TV and
It might be.
My mind went to the thing I read today in the court filing about Barbara McDonald's description of the F tree pick and the
yeah. I mean, that part's just a crock of crap, because we all know that the F tree is absolutely public. That one came out to everyone. As for the crime scene photos, oh, what, Adam?
I was saying thank you to Brutally Honest.
Oh, brutally honest. Waiting for that to go up. Thank you very much, brutally honest. As for the crime scene photos, those have made their way through multiple people in the Delphi case and wherever else. They are they got their butts in their head or something like that if they believe that they were just stopped at those couple of people. I know people that have received them and then deleted them. Anyways, there's a slew of people that have those crime scene photos, but they're not out in the media, so that at least that I know anything about.
But they're in the public.
But they're in the public. Absolutely. Don't be fooled by those words, but because it's not true. They didn't just stop at a couple people, okay? I can guarantee you right now that at least hundreds of people have those pics. Absolutely.
Right.
So,
which is interesting, with Travis, something that we can talk about later or on a different show. But, the definition of public when it comes to court documents, because, I know what my opinion would be. I personally think.
Hold on. I think
Thank you. I know that for myself, I consider the public being any single person that's not on the defense's payroll or the state's payroll.
Oh, sorry, Adam. I squirrel. What'd you just say there?
I said, I know that, the definition of public can be, subjective, but when I'm looking at, disseminated to the public, when it talks about crime scene photos or gag orders or leaks, I look at the public being defined as anyone that's not officially employed by the defense or the state.
Sorry.
But in what context?
When it says access to the when it says, like, if you read these motions in the documents that we read today, it talked about how the crime scene photos or the access to Baldwin's office was not available to the public. In the gag order and the things, it talks about the public. And then again, it talks about how these crime scene photos were not disseminated widely to the public. And to me, the public is one person. As soon as Mitch Westerman was given access to that room, that was a violation.
Well, Travis, can we go back to that again?
Yeah, but the way they're writing this brief, they're
when I read the brief, I read it in comparison.
They're not writing it that there was no violation.
No, absolutely they're not.
They're just writing it that all five justices were practicing attorneys at one point, and they just kind of know how this stuff goes. But what they're pointing out, I think, is, as I recall, is that they've taken safeguards to prevent it in the future. But the biggest thing was they cited cases that said disqualification is a harsh remedy, that you have to explore every other alternative, whether it's contempt proceedings, fine and jail time, or the other one that came up was you make a bar complaint, let the disciplinary process handle it. But at least according to that one Indiana case, only two ways to remove counsel of choice is they're not licensed in that state, or there's a legal conflict, and then you need to be careful about that too. But I'm guessing maybe the authors of the brief are using the word public in a different context. My reading of it was that, and we're going to come to that, I'm sure, again here in a minute, but that they're not trying to say, hey, look, this wasn't a violation of the protective order. It was that, I don't know, we'll need to come to a point where they're talking about it, but
right. I'm sorry, I didn't mean to jump
your viewpoint on it is as sound as anybody else that's reading it, and we'll see what the opposing brief that the court files, if they choose to file one, which I'm sure they will, but we'll see what they say.
Okay. Yeah. I just hate the way that that people that certain people, whether it's MS or the news or or defense or whatever, that they're making it seem like, oh, only a couple of people have these pictures. It didn't go too far. Bull crap. They have, but again, it's just a matter of for me, that's the only part. It's you know what, I'm sitting there listening and I'm just going up chuck a little bit on that one, because it galls me when that that's bullshit, and even if it's coming out of some people's mouths, like MS cough bullshit, because they know damn well that this has made it out a lot further, and then it's just trying to minimize it. It's just no, just tell the truth. These have made it clearly way out into the public. No, it just didn't stop.
Well, they're saying in this brief that they didn't become aware of it until whatever day, and they wrote a letter to the judge immediately. I know there's people are disputing that, saying, oh, they knew about this long before. They're arguing the record, and that's what's in the record, and they're attaching references in the record. What is that's why the stuff in the record is so important. What's the judge have that she's going to be able to put into her record that this thing got disseminated, it's widespread, probably involving hundreds of people. It's just not in the media.
Right.
When you say the record, do you mean the record including what's being stated in documents that are being written on the behalf of the sex defense team?
What's filed with the clerk?
Anything.
Or she had a full hearing, and she talked to and the state, and it was their motion to disqualify, presumably, right. And then it converted to hers sua sponte. But you call the the record would be if those investigators have been called and testified at the hearing and said, yeah, we tracked it here. And then we saw in these photos that that's the office conference table or however they lined it up. And, then we mentioned it to him, and then they voluntarily provided the phone, and then he sent it to 10. We talked to those 10, and they sent it to another 100, and, the way stuff goes. And, there are a lot of people, 95% responded to our request that it be deleted. We spent 400 man hours tracking this stuff down and trying to get it deleted and eliminated, but there's none of that. So,
but what is there? If what is there, like some of the things that are written by the defense, I mean, if there are people that can personally, personally make claims that, they were told firsthand from other parties.
Well, sorry, too late. It's.
Well, I'm saying if
she didn't conduct a hearing. I mean, people could write the Indiana Supreme Court. It'll get filed by the clerk, and action, but nothing because she didn't have a hearing. So
she did.
No,
she did.
She didn't have a hearing. She had a private. What's her court reporter say? She had a conference among counsel. She's imploding, Adam. She doesn't know what she's doing, and it's showing. And she
I disagree with that. I'm sorry.
It's a hearing. It's a conference. It's private and confident. I mean, it's really, really surprising. But did she have a hearing in those chambers? Or did she have her court reporter says it was a private conference among counsel
before a scheduled hearing to address the things that you're referring to, that you're saying there wasn't a hearing held for. And the reason there wasn't a hearing held for them is because the prior ex-defense team of Richard Allen, rather than face the consequences of the actions that they were being held against with the court,
she's screwing up and she's imploding, and it's sad because she's trying to do the right thing, but she just keeps making it worse. Hang on one second.
Hold on. I want to agree with that because that's how I'm feeling myself, to be honest with you. The more I'm looking at stuff, the more I keep thinking that, I don't know, I feel like that it's going to come back to bite her in a sense. I feel like, I don't know, Charmaine, just quickly on this. What do you guys think in chat with regards to Judge Gall? And what we're
Travis, I want to say, I'm not trying to be disrespectful. I hope you know that.
Opinions, that's all. Charmaine, quickly, what do you think of it? Do you think I kind of agree that the judge feels like she's imploding, and it's just like, I don't know. I feel that.
I do too. I think it's pretty clear that there's a bias for whatever, reason. She's just sick of the crap, but without knowing Indiana law and their trial procedures, it's hard to know exactly. And even listening to Travis and listening to Bob and listening to Brett, we don't know. We have no idea, and we're not going to know until the Supreme Court tells us if she's violated any rules of procedure, which by the looks of things and from what I do know, she definitely has.
Let's see. Hold on.
I try my best to stay biased because I'm so wishy-washy. I hear one thing and I'm like, I switch sides. So I live on the fence right now, but I can appreciate people that have good arguments on one side, but it's the people with closed minds that refuse to listen to the other side that It infuriates me. Like that's what the problem is here.
I mean, we all know, I just want to say one thing here. We all know that regardless of all this crap that's going on, at the end of the day, what the bottom line is, what we want is that Richard Allen have a fair trial and justice for Abby and Libby.
Right.
Unfortunately, there's all this stuff going on right now, and it's going to work itself out in whatever process it takes or whatever motion, whatever happens with Judge Fran Gull or not, or whatever happens with Rosie and Baldwin, if they get reinstated
Right.
or not. The end goal here is that this is obviously another big, this is another big hurdle that I really wasn't expecting, to be honest. I wasn't expecting this. Delphi is full of leaks. It's full of incompetence. It's full of a lot of crap. We just want to get to that day where finally it comes that Abby and Libby can have their justice. And if that's Richard Allen or not Richard Allen, that at least he has his fair process.
You guys want to be done with Delphi and just get to the end and justice for Abby and Libby. And that's just,
right.
I hope you guys are in it for the long haul, because you're going to be covering appeals for a decade, if not more, if he gets sentenced to the death penalty. I mean, this is everything that's going on right now. It doesn't matter how it turns out. This is all going into appeals later. Because I think that Richard Allen is the guy. I do. But because things weren't done properly, it's all going to be up for appeal later. So he's either going to get a new trial or he's going to tie it up in the appeals court. And you guys are going to be covering this case forever. So I hope you're ready for it.
You pretty much know that that's coming. Like, to be honest with you.
Right. I do want to say, Travis, I apologize if I cut you off. I respect your opinion, and I disagree, but I do apologize if I cut you off or if I was rude.
Adam.
Not to me.
Adam's always rude. Okay.
He had to go off camera to wipe his tears. Adam, way to go.
Well, no, I mean, I always want to be respectful and so I apologize.
I love a good debate. That's what I love. But as long as we can hear both of you, though, I love a good
I gotta
debate.
go to bed.
Yeah. Oh, and yes, Charmaine, she said we had her till 10. It's 10:30 her time. But you guys know we started later and stuff like that. So Charmaine, thank you so much and for joining us. And again, we'll see you tomorrow night with the Defense Diaries, Charmaine. Yeah, so looking forward to that. So
Charmaine, are you gonna wear your sexy glasses?
No.
If I have to read stuff.
Yeah.
I'm blind. I have 50-year-old eyes. I have no choice.
Where Charmaine lived there, they had the beautiful northern lights and all that going on. Just gorgeous. I shared those pictures.
One of my bucket lists. That's one of my bucket lists.
Well, my husband's from England, and all he could talk about was the northern lights in Canada, and I'm like, okay. But I guess it's a big deal to a lot of people that they just want to see the northern lights.
I've traveled all over, and the northern lights I've never seen. It's one of my bucket list items.
Yeah.
Did you show Adam the video?
No, I haven't. I haven't even looked at the video myself yet.
Oh.
I'm going to look at it later. I haven't looked at the video yet. It's been a hectic day of paperwork and, Travis doing a lot for us and stuff like that. Like, honestly. And then my husband, he was needy and needed my attention as well. Had to make dinner and stuff like that. So, yeah, it's been a day for sure. But anyways, we'll let you go to bed. Love you so much. We'll see you tomorrow with the Defense Diaries.
Night, guys.
Thank you, Charmaine, for everything. I appreciate it.
You too, Travis. Take care.
Okay, so let's. Oh, we just got ugly fast, didn't we? You guys know I hate it when I'm freaking I got 3 chins showing.
I hate that one. Right.
Okay, we're good now. We're good. You guys don't need to see all those chins tucked in there. But anyways, Travis, let's get on to number 2 here. And as fast as you want to kind of go through it, feel free. Oh. Travis is going to get his wine. I think Travis is crime and wine.
Yeah.
It's crime and wine time. Yeah.
Okay, I got it. Let's see.
Okay. I'm just going to, you just tell me where to go and you boss me around. I like it. Did you just hear that crack open? What do you have? Talk about it. What are you drinking? I heard the big crack.
This is just Waterloo soda water, non-alcoholic. It's club
Oh.
soda with lemon lime.
Okay. Did you guys see him wink? Okay. All right. No, just kidding. Go ahead, Travis. Whenever you're ready. I know it's late.
Let's see. I guess these aren't numbered paragraphs. So the top of page 5.
Okay, top of page 5.
Mm-hmm.
Okie top of page. What page am I on right now? Frick me. This is 4. Page am I on? That's 4. So top of page
4.
Do you want 4 or 5, Travis?
Top of 5.
Okay, so
Starts. Rick requested a public defender to represent him.
Yep.
Andrew and Brad were appointed. Attorney Baldwin is one of only 4 Indiana attorneys certified as criminal trial specialist
yeah.
by the National Board of Trial Advocacy. That I highlighted that. That's a big deal. Let's see. 1B toward the bottom of 5. Rick's lawyers issued a press release affirming Rick's innocence on November 29, 2022. Charging information and probable cause affidavit in Rick's case were made available to the public. Baldwin and Rossi issued a press release which responded to the allegations contained in the affidavit, reasserted his innocence, and indicated they would continue to share exculpatory information with the public to the extent they were ethically permitted to do so. And they cite the record, the press release, those pages 46 to 48. Later that day, the court entered a gag order prohibiting the parties from making extrajudicial statements about the case, which was reaffirmed after a hearing. And they're referring to the court docket on pages 11 and 14. The court also entered a protective order prohibiting the parties from divulging or granting access to the discovery material to all but certain people.
Sorry, where are you? What page am I on?
Oh, that rolled down from 5 to top of 6.
Okay, top of 6.
Yeah. Later that day, the court entered a gag order and then protective order. And then both of those things are in the record. However, there's no written order on the gag order. There's just a minute entry in the clerk's docket. So, you know, she's going to be pretty hard pressed to say, well, that was supposed to include statements and pleadings. I mean, she didn't even bother to do a written order. There's just, I guess, the minute order, and it says, you know, what it says in the clerk's minutes. Let's see. Then the top of 7. It says, are you there? Attorney Rossi filed a tort claim notice to preserve Rick's right to obtain private counsel in the future to file a civil suit relating to the conditions of his Department of Corrections confinement. Developed a strategy, we all know it is by now, speedy trial and third-party guilt. Talk about signing the motion that they were planning on filing. Then during a telephone conference with the court in early 2023, Rick's attorneys informed the court that they were ready to proceed to trial in January. Then there's the removal, talked about in August. Mitchell Westerman. And then going down, we're now middle of page 8. After receiving Rick's letter, the court notified the parties that it was scheduling a hearing on October 19th to address other matters which have recently arisen and ordering Rick's counsel to cease work on his case until we meet on the 19th. Then this I didn't understand in the pink purple. On Rick's request, the court ordered the attorneys to appear in chambers at 12:30 p.m. That can't be right. Or Adam, you see what I'm talking about? That doesn't make any sense, does it? On Rick's request, the court ordered the attorneys to appear in chambers at 12:30 p.m.
Oh, yeah. On Rick's request. Well, but they use that a lot.
I think they mean at Rosie's request.
Yeah. Well, sometimes they use that verbiage, though, where it's like on Rick's request. And I'm like, come on now. We all know that Rick didn't request it. It was frickin' Rosie. And, you know.
Well, that could be. They were putting it in the client perspective. But
well,
anyway.
They do that a lot, I noticed. They put it in the client because half the time I want to like almost upchuck when they use it that way, just because it's like, come on now. Rick doesn't know anything about this stuff. This is the attorney stuff, and they're giving him guidance, and then he'll just probably say, "Oh, good," you know. But anyways.
Then going down to the next page below that, on October 19th, 2023, the judge opened the courtroom to the media and for the first time authorized 1 or 2 cameras providing pooled coverage to be permitted in the court session. The attorneys appeared in chambers without Rick being present. During the conference, the trial court read a prepared statement to Rick's counsel accusing them of gross negligence and citing specific examples. The purported acts are in that red box: issuing a press release before entry of the gag order, filing motions to protect his health and safety, unintentionally emailing a discovery log to a third party, unspecified improper statements made in the motion to suppress, filing a tort claim notice, Attorney Baldwin hiring a lawyer to appear on his behalf on the issue of sanctions, and third party impermissibly photographing discovery without the knowledge or consent of either lawyer. Then down to page 10, talks about the Hobson's choice, and then I highlighted and put a red box around the footnote because I know Adam likes footnotes. The court reporter declined to provide a transcript of the in-chambers proceeding, and the court did not rule on relator's motion for the transcript. The relator is relying upon the recollection of Rick's attorney as memorialized shortly after the proceeding. So that is, that's putting it on the judge to decide what she's going to do on that. And she now has a Hobson's choice. If she thinks the discussion was different, she's going to need to get that transcript made and produced. And then, you know, she can point out, no, this other thing was said, and it's going to come right back at her. Well, we gave her multiple opportunities to get this thing prepared, and she wouldn't do it. We said we were relying on their memories as best they could, but, you know, nobody's perfect on that. Now that we have the transcript, you know, it's just going to be argument, counter argument, back and forth. But she just really seems like she doesn't want to hand that thing over.
Well, that's what I was going to ask you about this, because, you know, because a lot of people with this piece right here, right? It's like, okay, so Bob and Sleuthy Goosey requested the audio, okay, declined, okay. Then we see in here that the court reporter declined to provide a transcript of the in-chambers proceeding. My question is, well, first of all, she's deeming it as a confidential in chambers thing. A lot of people are saying that, or that Rick should have been inside the chambers as well, let
Yeah.
alone the fact that these transcripts, that like, why isn't she providing them? Like, shouldn't she have to? I don't know. Like, it seems
Well,
like she's not wanting to give them up, right?
Yeah, that's, they filed a motion in the Supreme Court
Yeah.
for a transcript to be prepared. We won't have time to get to it today, but before we started, I said that to me, that's one of the most important documents that got filed today is that they're asking the Supreme Court to order her to get a transcript prepared. And that just doesn't look good for her. Now, of course, if they deny it and say, she's perfectly within her rights to consider that a private meeting among counsel, which really begs the question why it would be recorded by the official court reporter. But, that may get resolved in her favor, but I doubt it. She's now forced to either come forward with her own affidavit about her recollection, and more specifically, her attorneys are on the horns of a dilemma. They can't say, hey, go ahead and have her make the transcript. We'll take a look at it and then decide what to do. Court reporters under an ethical obligation, if she does prepare an official transcript, she's got to make it available to attorneys for both sides.
Right.
I suppose if the court reporter, and they're very beholden to the judge they work for financial reasons and a number of reasons, but in any event, they can go and listen to the recording and say, well, I can't find where you said this, judge, or, it's plain as day that you said that, judge. That they could do something like that. But once you, order the whole transcript, be prepared, it's got to be made available to everybody. So if she's disagreeing with these facts of what occurred in that in chambers conference, she got two choices: either lay out an affidavit, and then if she does it by affidavit, the Supreme Court's just going to automatically order a transcript and say, y'all are saying two different things, and we know that there's a tape that will settle the disagreement, get it made.
Right.
Then they point out this, what I've always perceived as a problem.
Thank you.
The judge entered the courtroom, went on the record without Rick or his attorneys being present, and stated there was a unexpected turn of events and that Rick's lawyers had withdrawn from the case. The court concluded the hearing by noting that the state had some witnesses here that came earlier to have the hearing, but clearly this is outside of our control. Now, I don't know what the hell that's about. What hearing and what witnesses? I know that's the law enforcement officers that were there. I mean, did they have them there to make Baldwin and Rozzi think law enforcement was going to testify about the leaks and this had gone to hundreds of people to provide pressure? But they're pointing this out without really being specific about it. But what hearing was scheduled that day and what witnesses? But I checked the accuracy of that quote on page 2 and 7, and it appears to me that's an accurate quote. Noted that pretrial motions are still pending due to the court reviewing the exhibits submitted by counsel. We're aware of that. Then they talk about how they came in as private counsel. They talk about here at the bottom of page 11 that what they were doing doesn't constitute gross negligence.
About page 11. Okay.
That's at the bottom of 11, and now I'm at the top of 12. They talk about the motion to disqualify the judge. The court ordered the clerk to remove Rick's filings from the record because Rozzi was no longer counsel of record. The court also appointed 2 public defenders. Then in that red box, Attorney Baldwin filed a motion requesting the court reconsider her order to remove he and Rozzi as Rick's counsel of record. In the motion, Attorney Baldwin argued that his oral motion to withdraw was involuntary. The court rules outlining the proper procedure to withdraw as counsel were not complied with. He and Rozzi were not disqualified and remained as counsel of record at the time they filed the motion on Rick's behalf for the judge's recusal. The court lost jurisdiction to take any further action in the case until the motion to recuse was resolved. And the removal of counsel interfered with their attorney-client relationship and prejudiced his constitutional right to counsel. So all of this, that's, middle of page 12, go over to page 13. All of this, they're laying out what's in the record that the court can consider. And go ahead and go over to the top of 14.
Okay, let's see. Top of 14. Okay.
Grounds for the writ of Mandamus. We've heard this before. Original actions. This is Roman numeral 2. Original actions, extraordinary remedies, and accordingly, writs of Mandamus and prohibition will be issued only when the trial court has an absolute duty to act or refrain from acting. The court routinely relies on its original jurisdiction to address claims that attorneys have inappropriately been disqualified or that they should have been disqualified.
Did I go? Oh, sorry.
Citing an Indiana case that it's appropriate for a writ of Mandamus, which is, why the judge, probably Chief Judge of the Indiana Supreme Court, ruled that they wanted briefs by the 16th, and then they're going to consider it. And then they mentioned the Sixth Amendment right to counsel. In all criminal prosecution, the accused shall enjoy the right to have assistance of counsel. The right to counsel embraces not only the assistance of counsel, but also the reasonable opportunity to secure counsel. Going down to top of 15, next page. The attorney-client relationship is afforded the same venerable protections, whether the lawyer is a public defender, acting pro bono, or privately retained. Smith is a California case, old, 68, and then they cite Alabama Criminal App 2010. Again, not Indiana cases. Again, they point out Indiana recognizes only 2 narrowly subscribed situations where a trial court may sever the attorney-client relationship against client's wishes. We'll look another day at the law that Adam found to see, and then we'll also see, how they respond to that in the reply brief on behalf of the court, Judge Gull. In this next quote, no Indiana court has ever tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or even grossly negligent. And they say Indiana has never, ever done it. And then we went to other state courts to see what they've done. And they've ordered reinstate defense attorneys who have been kicked off cases for conduct the trial court found upsetting or negligent. And then they list those cases there. On to the next page, 16. Now they're laying out what other courts have said the proper process should have been in this case. When a court believes it possesses objective evidence supporting a lawyer's removal, it should clearly articulate that evidence on the record and exhaust other possible remedies before resorting to the removal of counsel, such as censure, disciplinary referral, or contempt proceedings. Removal, if ever considered by a judge, should be an absolute last resort, and the removal proceedings should occur at a hearing where the defendant and his chosen counsel are provided notice and an opportunity to be heard. And, you know, if that's true, and that's what Hennessy has been arguing from the beginning, that day he came in with the brief, and then from what Frank reported, told the judge that on the 31st. I think the transcript is going to support that, you know, this is what the law says, and it was done to make a record, so it's here. Now we're at the bottom of 16. But
Travis, can I just quickly ask one thing that Ivy was wanting to know, and if you know the answer? She says, how long does it typically take for this Supreme Court to accept a motion for a writ of mandamus? Do you kind of know the answer to that, perhaps?
Yeah, it takes usually takes a day. In the first writ, they accepted it the first day and ordered briefs by a certain date, and then the judge's attorneys asked for more time and extended it a week because the attorney general declined to represent her. And then on this one, they accepted it the same day and ordered her, if she wants to file a response brief by the 16th. And then, Ivy, it just depends on how long it takes them to decide it. Could be quickly, a week, or, you know, if there's some disagreement among the judges, I mean, and they're hashing it out, you know, it might take 2 to 4 weeks, but I'm thinking a week to 2, because if they address the merits, if they decide these issues, they're going to have to issue some sort of an opinion in order to give future defense counsel and future judges guidance if they rule in Allen's favor. And then if they deny everything, it won't need to be as long, but still they'll need to give some sort of guidance for future defense counsel.
And she says,
the brief's due the 16th. And so, you know, I'd say sometime in early to mid-December, there'd be a decision. Unless they all take off for the month of December, then it'll be January. I don't know.
What does she say here? Knowing what the hearing will be about isn't the same thing as providing official notice.
Yeah, they if what Rozzy says is true in the verified, which is under oath, notice of continuing representation that he filed, and their affidavit that they submitted as part of this writ, it's one of the last exhibits. If what they say is true, happened in that in-chambers hearing, there wasn't proper notice and an opportunity to be heard. You know, assuming it's true, they were, and I don't know who made that comment, but that's dead on.
Ivy?
Yeah.
Yeah, Ivy.
So Ivy, that's this law that they
Ivy.
what?
Oh no, she said perfect time for the holidays.
Yeah. So top of 16, when a court believes it possesses objective evidence, and then, you know, it should take these lesser avenues, and then if it decides to go for the ultimate sanction of removal, should occur at a hearing where the defendant and his chosen counsel are provided notice and an opportunity to be heard on why it should be severed. And there was no hearing. You can't have a private hearing in the United States.
Right.
Absent that, you know, it's a FISA court type of deal dealing with national security, which this isn't, or Serpico is, you know, needs his identity protected, but even then it's a public hearing and they put him behind screens in the courtroom or have them testify by remotely with a disguised voice from another room, but the public's there.
Right.
And so, you know, so she gives them this alternative, and, you know, they're going to say, well, they waived a hearing, but it doesn't get them around the notice part. If what they say is true, that they were told, yeah, be there at 12:30 to go over some stuff, that's not notice. The emails tend to bear that out, and they're attached as an exhibit.
Didn't that line say? Didn't it say at Rick's request they met in chambers at 12:30?
Yes.
No, that they recorded it.
No.
No,
It said at Rick's request they met at 12:30 in chambers.
Yeah. That's when you were talking about Travis, remember when you said, does this sound right? And I said to you, well, that's because they keep sometimes using it like at Rick's request.
Yeah.
And
If you read it, it says at Rick's request they met in chambers.
Yeah, the email talks about.
No, I'm not talking about the email. I'm talking about the filing made by the defense.
Okay. So, what do they reference at Rick's request? What do they reference in the record? I mean, we can figure it out. Just go to that reference.
You talking about up in this document, Adam?
When
it said at Rick's request?
Yeah.
Yeah, that was like.
I've so many of these documents now. I have to remember.
It's okay. Let me see here. See if we can find it.
Page 8 on Rick's request. The court ordered the attorneys to appear in chambers at 12:30 p.m. before the hearing.
Yeah.
To discuss what was expected at the hearing.
Yes, at Rick's request.
Right. And what is 227? I'll bet you it's an email.
Oh,
But
I see.
I don't know what the point is, because we know what those emails say. I mean,
no, I know. I'm just.
it wasn't notice.
I'm not saying
They
it was
said,
the.
what are we going to be here for? And her response was,
Okay.
both of you all need to be in my chambers at 12:30. So that's what the record is. It's clear as day. She didn't give notice. And, the worst part about it is she came out in court and said, we've had an unexpected development, and that,
Right.
that
Right.
total bullshit rolled off her lips as easy as.
Right.
And Ivy, I don't have Ivy. I don't have an argument. It was just when you're talking about that. I thought that line was interesting.
Which is why I didn't understand whether it's, when they're using Rick, meaning his attorneys, I think it's a mistake.
I think that they wrote it wrong.
They sent an email to her, hey, you told us to quit working on the case, so we're trying to figure out what the heck this is about. And then she sends an email back saying, we're going to have the hearing in my county, and I think, and you all make arrangements to be in my county and to appear at 12:30. So yeah, they got notice to be in her courtroom, but they didn't get notice of a hearing. But I don't understand why it says at his request, because the emails are really clear. But what was that? Let's see, that's page 8.
So are you saying that she missed a step there? Basically, it went from.
No, I'm not saying anything. What they're saying is, and what Baldwin was telling her multiple times, what they're saying in this writ is that one, removal should be last option. You should try and cure deficient performance through censure, through disciplinary process, or contempt, or violation of a protective order, discovery getting leaked. Your last option should be removal. But if you do removal, according to them, the courts say you can only do that if the defendant is present, which is all I've ever seen, because they always ask the defendant, even if the defense attorney wants to get off for non-payment, they always ask the defendant, do you object? And 9 times out of 10, they say no, because they know they haven't paid in accordance with what was agreed to, or they said, well, I told them I'm selling this, or you hear everything when you sit in court, and I'm going to do, what's that thing where you get paid? I'm going to do a drug trial. Must have heard that a dozen times. There's a lot of those companies where they pay people a lot of money to do a drug trial in Central Texas. Anyway, well, I'm signed up for a drug trial and I can pay them, or, hear whatever, but they always have the person there, or at least, judge, I sent them notice, so on and so forth. But so this says record 1, page 227, and let's see what that is. That's in his verified notice of continuing representation and In an October 17, 2023 email, Attorney Rozzi requested a conference to determine what the court, prosecutor, and defense counsel are trying to accomplish on Thursday, especially in terms of what is expected of us while we are on the record in open court. In response, the court ordered both the defense and prosecutor to appear in chambers at 12:30 on October 19.
There you go.
There we go. So, so that's pretty much it. Gone
That
through.
could be taken ways.
Okay. So just quickly for my own benefit, so just put that back for people that just came in and that were confused maybe about what we're talking about here.
Yes. What's the question?
Oh, just about the whole request, whatever, Adam, you were talking about there. Don't ask me. My brain's mush. Just whatever you guys were talking about there about that.
Oh, just it said that his counsel made the request and for the conference, and
Richard Allen's, right?
That if she's going to say that was the hearing,
Right.
and that was the notice, she's going to be hard pressed. But we're kind of wondering, well, why did they put Rick requested the conference?
Right.
It's just to lay out an accurate flow of what happened, but it's not. They're very clear that
That's not what I'm saying.
that they didn't have notice and an opportunity to be heard. She'd already made up her mind by reading the stuff, and I at first it might that they requested the conference might be inconsistent with their factual summary or whatnot, but I don't think it is when you read the reference that she asked for a conference, meaning a phone conference, to figure out what are we going to do on this day. And then, you have to go back to the order setting that date, which doesn't say anything. It just says other matters, which they knew, and they acknowledged it had to be about that, but it wasn't specific.
They filed a motion that morning stating that they shouldn't be disqualified.
No, I'm talking about this thing on the 19th.
Yeah, so am I. Remember the morning of the 19th.
Oh, yeah. Because of what she said.
Well, the state had requested it during their phone conference.
Yeah, I mean, it was all in context. And so she started with the email saying, stop working on the case. And then they're like, what the hell does this mean? So they said, hey, can we have a conference to figure out what is going on? And then she said, yeah, be there at 12:30. And then, they could see the writing on the wall.
Right. But then even on the 11th, Richard Allen himself apparently wrote a letter to the court requesting that they not be removed from the case.
What date?
So the 11th.
Oh, yeah. I mean, you have to go through that record, which is 250 pages long. And she talks about all of this stuff in order. Mm-hmm. And from their perspective, again, just their perspective, we got to hear the other side. this wasn't, if her intent was to remove and she was hoping to spare them, in a sincere way, again, I keep saying it over and over again. I think she sincerely wants to do the right thing, but the manner in which she goes about doing them in secret, again, this was all of these communications by email, and then, there's this phone conference apparently where the prosecutor brings up disqualification, and so yeah, it's real unfortunate. I wish that thing hadn't happened in August, because
or November, or
it sounds to me like the prosecutor was really, really sweating it out, and that and suggested disqualification was his only avenue.
Right.
And, I don't know it.
Well, and Travis, isn't part of what we're talking about kind of what the Supreme Court's going to be debating?
For a writ to be granted, this stuff shouldn't be debatable. It should just be, does this apply? Was she required to do this? Was she required to do that?
So it'll be interesting to see how they interpret it.
Yeah, it's they could surprise me and say, yeah, she's right. You don't have to prepare a record of that. A judge can just on their own determine that these things constitute gross negligence, and that's enough in Indiana. But you got to understand how these associations work, whether it's prosecutors or defense attorneys. But every defense lawyer that does court-appointed public defender work in Indiana is looking at this case. And that's why they also, Baldwin and Rozzi, seem to have an endless string of attorneys that, there's probably a strike force of volunteers that are coming in that do this. So it will be, it'll be interesting to see what
it will be. And Travis, do you think, am I wrong when I think that it'll probably be studied in Indiana law, in Indiana law schools, after whatever happens? Because I think this case is unique in so many ways. I think it's going to be studied in law school.
Well, it will certainly become part of, regardless of how it's decided, but it'll certainly be part of the what they call professional responsibility course, which is legal ethics and the professional rules that we have to follow. And possibly also criminal procedure course, but it for sure will be the subject of Indiana professional responsibility courses. There's no doubt. And go ahead.
No, I was just going to say, because we're it's 10:16.
I've got to go to bed soon.
And I know we got to get going here, and Travis has had a long day. So I want to finish up, but will we be able to watch, like Steffa says, will we be able to watch the Supreme Court discuss? Like,
So I don't know enough about direct action, writs of mandamus in Indiana. They may rarely grant oral argument. Oral argument, is something on appeal that you typically have to request, and some courts they routinely grant oral argument, and others it's rare. And so if they order oral argument, which is a big question, but I would say is probably rare. Because again, this stuff's supposed to be clear cut. She was required to do something and she didn't do it. And it's not a court of record. You don't call witnesses and cross-examine them, and the Indiana Supreme Court figures out who do they believe, Gull or, Rozzi and or Baldwin. It's strictly from the record, the pages, and all of the arguments on paper. Here's the start of it. So most states don't have oral argument on this type of writ. But if they did argue it, I don't know if Indiana Supreme Court allows cameras or recordings of their oral argument or not. Most courts have gone that way, and those that didn't converted in the pandemic and then continued using cameras and recordings. Texas was that way, but at the trial court level, Adams found stuff, and then I've seen stuff on my own that, they're pretty conservative when it comes to cameras. I was pretty surprised that I don't want to say antiquated, but that they had very high, hardline, strict rules against cameras in the courtroom. And I thought it was only the federal courts that were that way, but they've just recently allowed judges to consider it.
you talking about in Indiana?
Yeah.
Yeah. Yeah. Mm-hmm.
Yeah.
So if they allow oral argument, I don't know the answer to what they've been doing, but we could figure that out really
Travis,
easily.
You know who was part of the pilot program with the cameras?
Franco.
Absolutely.
Yeah, she's innovative. So
Yeah, that's what her thing says, doesn't it? Okay. Anyways, you guys, I need to move on because husband's going to need to go to bed soon. So let's just finish this one out here and then call it a night, because I know it's late there. It's almost at the 3-hour mark. Yeah. And even though I could literally sit here for hours.
And Travis, what you're saying, everything you're saying is so invaluable. We appreciate it so much.
Yeah. That came out of my mouth too. He's blushing. That's why his camera's off. He's blushing. No.
Let's see.
So this is where you left off on page 16 here. So did you want me to stay here, go down further? Sua sponte.
Sonny, he forgot how to read because he spent too much time with us.
Yeah. Let's see. It's just restating the same stuff. Bottom 17. Just restate it another way, and then go down to the conclusion.
Which one's that?
It's 19, red box around it. To ensure that going forward, Richard Allen receives his fundamental right to counsel a writ. A mandamus is appropriate to reinstate the attorneys, set a trial date within 70 days, and remove the judge. So that's what they're asking for. And,
Yeah.
We shall see.
Yeah, we shall see. Yeah, let's leave it there. Okay, let's Travis, thank you so much.
Oh, you're welcome.
No, thank you so much for, like I said, going through these documents and highlighting them and stuff like that. And we all know that usually on this channel, never does anything really go as planned. We might think we have a plan, Travis, of getting through 1, 2, 3, and 4. But then it always happens, right, where people are asking questions of stuff like that and stuff like that. So you know what?
She means
It's
me.
very what?
She means me.
No, not at all. You know what, Adam? Well, I mean, hold on. No, because there's always questions, and I know that, like I said, more stuff about this whole law thing. I can read the documents and understand it. I need to absorb things. There's a lot of stuff, like a lot, like I just kept getting sent like a lot of documents and doing stuff today. I didn't necessarily have time to read everything, that's for sure. But then, I knew that you were coming on tonight to, again, go over things and explain it. And people, like I said, Travis, like, this is your expertise in this area, and Adam, I love a good debate when you guys, are going on. Because again, right, like, you're not in Indiana, so you don't know necessarily all of the, like, the SC thing, for instance, and all those things. But for the general, the general consensus, how most states or judges or how things go, pretty much is somewhat similar at the, whatever.
But I appreciate it, Travis, because I'm not a lawyer. So any question I have is just my layman's brain having this thought that I'm like, hey, well, what about this? So I appreciate you responding and being patient with, the questions I have.
Well, if I knew what I was talking about a lot more, I'm one of those ones too. I love to ask questions and stuff like that. But for me, this is more like, besides reading it and okay, you get the gist of everything. Like I said, for a lot of people that are watching the live or that come across this live, it's very, like I said, knowledgeable for people, just to, help people understand these documents. Because most people that read these documents, for the most part, have no grasp of truly what they mean. All these words like lamine or whatever that word was and stuff like that. It's like, wait, what? I mean, I was shocked when you even said, is that what it is? Lemony?
Motion in limine.
Lemony, right. And here I was like, I got
Lemony.
this.
Lamine.
Yeah, I would have been saying lamine the whole time. But even just something as simple as that, it's like, oh, okay, learned a new word today. But anyways, Trinity, Gilherd, thank you guys. Thank you for your PayPal, Trinity. Thank you, Gilherd, for your $10 super chat. Yeah, thank you guys for joining us tonight.
And thank you, Brutally Honest.
Thank you, Brutally Honest. Oh, right, sorry, I almost forgot that one. That was $2 super chat there. Sorry about that, Brutally Honest. Adam's fault, totally. But anyways, we're going to be again live tomorrow night with Defense Diaries. Charmaine will be joining us. I hesitated because I wasn't sure. That's 5 people on panel. So I wasn't sure, Travis, to be honest, if you wanted to join tomorrow's night's live or just sit in the chat or what. I didn't want to impose or have it so that people overtalk, if that's the case. So I'm not sure. If you wanted to participate, Travis, let me know privately.
Okay. Yeah, I'll do
Yeah.
that. I'm not sure what I got going on, and but
Well,
you
I
know,
just
I'll let you know. Yeah,
I just want
always wanted the chance to meet and talk with them, and
right.
I just like I was saying earlier before we started, I'm really sensitive to the fact that I don't step on their toes when I'm chatting in their lives, or it's in the sense that I only want to pick up stuff that maybe goes unanswered, that they either overlooked or don't have time to deal with because it's way off or something. And just trying not to, because they've got two attorneys talking about all the legal issues, right? Plus they're dialed in some form or fashion to the point where they know when a writ's going to drop and get a thank you on X, formerly known as Twitter, or whatever it was, by the defense. And, so everyone, from the legal side kind of understands what the issues are. The big stuff was a couple of 3 weeks ago when I was posting, okay, this is what has to happen next, either an interlocutory appeal or a writ.
Right.
And then
Yeah.
the writ came and everyone thought I was a genius, but it's not the case. It's just, it's like putting together a carburetor from Cousin Vinny. You put a rag in it so the jet doesn't go down into the manifold. I mean, you follow a procedure. And so you're looking at this stuff. Ideally, an interlocutory appeal is better because it doesn't have to be something that the judge is required to do. It could be, it's better for the defense. They have more room to argue. They've got to show on these writs exactly what we read, that something that they're absolutely required to do, that they're either not doing or, refusing to do. So
Right.
it's, I just don't like to step on their toes in that way.
I get it.
Anywho, I'll see what I got tomorrow, and then I'll let you know
Yeah.
if I can look at.
I know. I would like to research and write one of those documents rather than change a carburetor, if I had to pick.
Yeah, in there.
And my brother works at NASCAR, so I mean,
Wow.
Oh, really?
you think I would pick the other one?
Anyways, thank you guys. I'll say, look, gotta get going here. But Travis, I'll talk to you later, type of thing. And like I said, so come join us tomorrow night. Defense Diaries will be here regardless, and whoever else pops up will pop up. Yeah, we'll just leave them by themselves, right? We'll just invite them to the show, and then we'll pop ourselves off back.
And Travis, again, I do apologize if I interrupted you at all tonight. I apologize.
Adam, that's about your 10th. Sorry, Adam.
Well, no, I do. I never mean to be rude. But I do apologize if I interrupted you.
Yeah. I don't apologize if I interrupt, Adam. Just can't do it. Can't do it. Nope. No. Anyways, thank you, Cowboy. Thank you, Travis, very much. You guys, we're going to end the live now. is there anything at all that either one of you wanted to say before we go? Anything?
Not for me.
Nope.
Nope, we're good. Okay. Thank you guys. Have a great night. See you tomorrow night on the live. And other than that, again, thank you guys for watching and joining us tonight. And thank you, Travis. Thank you, Charmaine. And thank you, Adam, of course. And thank you, Sunny. Oh, you're welcome.
Oh, thank you, Sunny.
Thank you. No, don't mention it.
Hey, you scroll.
This is Sunny Justice and Aspen Connor from It's a Crime and Shame, wishing you all a good night.